Hi, this is Deb Wenger. Today we're going to be talking about Media Law, Chapter 13. So your textbook is very, very detailed, and many of these topics are extremely relevant to anybody who's planning to go into the field of communications. But as our class focuses on media literacy, I thought it might make more sense for me to really highlight what I consider the most important elements from the textbook, and also update and take it a bit further on some of the more important topics. So first of all, when you talk about media law, you almost have to start with the First Amendment. So those of you who have had civics classes or might have had a media law class before certainly know that the First Amendment guarantees freedom of speech and the press. So right in the middle of the most important fundamental principles which our country has been built on is the principle that we should be free to be able to disagree with our government, with each other, and that we should be able to publish this information to get our views more widely known and disseminated. So this is a guarantee from the most important document in the country in many ways. So it also comes with a great deal of responsibility, and we're going to talk about that certainly in the ethics chapter. So the roots of American free speech, there were several cases referenced throughout the text. Again, makes for some interesting reading. But I'm really going to focus in on and highlight what I think are a couple of the most essential. So John Peter Zenger was essentially an editor with the New York Journal, and he accused New York's governor at the time of corruption. The governor had Zenger thrown in jail for what was called seditious libel, which is essentially libel that criticizes the government. Ultimately, Zenger's defense is that this information is true and was able to prove that to the satisfaction of the jury, which found him not guilty. And this established a really important principle that truth is a defense against libel. So what are the elements of libel? Well, first, it has to be damaging to a person's reputation in some way. So the concept of defamation. Second, you have to be able to identify the person that the libel pertains to. So for an example, even if I don't use a name, if I give you enough details so that it's pretty clear you know who that person is, that you could still be sued for libel. And of course you can be sued regardless of whether or not there's a legitimate case, but in terms of how do the courts define libel? So there has to be damage to the reputation, and you have to be able to recognize the person being defamed. And then finally, the story has to be published or broadcast seen by a third party. So, it can't be that in my own home I tell my husband something that's potentially libelous and it goes no further, then that's not libel. So how do news organizations defend themselves against libel? In my career in television news, I was actually involved in a couple of libel cases. In all of the situations I was involved in, the newsroom prevailed. In other words, the newsroom was found to be not guilty of libel. Again, most often because it's truth, that you can prove that what you had to say is actually accurate. Of course, that can be more challenging in some situations, but by and large, truth is an absolute defense against libel. Privilege. So when you are using information that comes from a government meeting, in a court session, or government documents, that information is protected against libel when you publish it. So if the courts got it wrong, if the government got it wrong, and you publish that, it doesn't matter that you've published it. The government got it wrong, and then you can assert the privilege that says, I took this from a source that I expected to be accurate. Publishing opinion is also a defense against libel. So if I'm quoted in the newspaper as saying, all of the police officers in Oxford are very mean and rude, that's my opinion. So that cannot be used to sue me for libel. Again, somebody can sue you, but are they going to prevail? No. Absence of malice defense says that for public figures, so people like celebrities or public officials like the governor of the state, the news organization has to have had the intent to libel that person. So it could be inaccurate. It could essentially cause damage to their reputation. But ultimately, if you can't prove that they intended to do that, the news organization or the individual is protected. Okay, so although for the most part we operate in an amazingly free society as journalists, there have been limits on free speech that affect both journalists and the general population. And I would expect that there will continue to be challenges to our ability to speak freely and publish freely. So post 9/11, the USA Patriot Act was passed. Under the Patriot Act, the government was given more latitude to use wiretaps and domestic surveillance. It also widened the definition of what constituted terrorism, so the bar was lowered, and it essentially allowed government to examine individuals' media use. So that's why this becomes important to us when we're looking at media law. The Snowden case, Edward Snowden, as many of you likely know, is caught up in the USA Patriot Act in many ways. So Snowden, in case you don't recall, leaked documents showing massive NSA data collection efforts. So they were essentially tracking cell phones, emails, web use of millions and millions of Americans that have no ties whatsoever to terrorism or constitute any kind of threat to national security. Snowden eventually fled to Russia, facing U.S. criminal charges. As of April 2015, he was still in negotiations with the U.S. Attorney General, Justice Department, about whether or not he would serve prison time. He has said he's willing to serve prison time, and that he all along has done this because he felt what the government was doing was wrong and needed to be exposed. Now, in 2015, in just a couple of months, in June of 2015, Congress has to take some action and determine what it's going to do about the USA Patriot Act, which is about to expire. Google, Apple, a number of tech companies have kind of joined together. You see here Google has a petition, an online petition it started, to try to get Congress to reform the surveillance laws in conjunction with the USA Patriot Act. So to change the amount and the ways and the targets by which the government gathers information on media use by American citizens. When data is collected, it has the potential to be shared and used. So the question becomes, when is it actually in aid of protecting our country, and when is it just easier to capture information about everybody and then figure out how you're going to use it? That doesn't seem to be a legitimate reason in the minds of some people for gathering all of this data. So another element of the Snowden case involves something called a shield law, which your textbook talks about. Essentially, a shield law is a law that gives journalists special protection from testifying in court about stories and sources. So this is a situation in which somebody acting as a journalist can be protected against having to testify about where they got the information for their stories. So because you're a journalist, there's a different set of circumstances applied to you than to the general public. About 40 states have shield laws. Mississippi is not one of them. And there is no current federal law protecting journalists. Now, the closest I think that we've come in recent history is 2013. A federal shield law actually made it past the Senate Judiciary Committee, but never got any farther. And one of the reasons why a federal shield law is such a difficult thing to come up with is that in order to figure out who's protected, most people think we have to define who is a journalist. And that gets us into kind of murky waters. You know, if I'm a journalism professor and I write something, am I a journalist? If you are posting to your Facebook page that is part of your news organization's social media outreach, you're operating as a journalist. But then when you post to your personal page, are you still a journalist? Well, fortunately for Glenn Greenwald, who was the first person to report on the Snowden documents, Snowden was willing to share his identity. He was willing to have that published. And that likely protected Greenwald from having to face either federal charges compelling him to testify on the source of the information. There have been instances, one of the most recent is the New York Times reporter Judith Miller, who went to jail for 85 days. She refused to testify in the Scooter Libby case. This is probably old enough now that it's murky if you remember it at all, but it involved the leaking, the deliberate leaking of the name of a CIA operative for political reasons. Libby eventually came out and said, yes, you can use my name, but Miller chose to go to jail despite that to make the point that if sources have to fear that their names will be revealed, then that's going to make it much more difficult for journalists to do their job, to monitor the government, big business, etc. So again, this is all tied up in the question as to who do shield laws protect? Do they protect your average blogger? Do they protect independent journalists who, you know, most of the time work at Home Depot but sometimes write freelance articles? But this is an important element of an important element of journalism because it allows journalists to tell stories that they might not otherwise be able to report. So I love the opening section to the textbook for the chapter on media law that profiles this woman, Barbara Ringer. So she's really considered one of the key developers of modern copyright law. She took care of extending the length that copyright would be enforced. More than anything, she wanted to protect the creator of content, which certainly any of us who do write or take photos or create artwork very much appreciate. She also extended or expanded copyright into new media. So realizing that it wasn't just books or television programs, that there were many new forms of media that copyright needed to cover. And she established the concept of fair use. So fair use is what protects you to be able to use a portion of something that's reported in the New York Times into your research paper with proper attribution and citation, of course. Fair use is actually behind what allows me to use this photo of Barbara Ringer. I'm using it for educational purposes. I'm not benefiting financially from using the photo, and I am not lessening the value of the photo to the original photographer. Now, copyright is still very much in flux, and our understanding of how copyright should be protected is very much still the subject of a number of court cases because of digital technology. So right now, Fox is being sued for using this photograph of the firefighters raising the flag following the attacks of 9/11 one of their correspondents essentially posted this photo along with a photo of the flag being raised in World War II on Iwo Jima, and used the hashtag #NeverForget and invited comment on that post. So Fox says this is fair use because one of the things that fair use is applied to is use of somebody's material in order to encourage comment or criticism, and this idea that the use is transformative. So I think back when we talked in the music chapter about DJs who were using portions of songs and blending them together to create a new genre of music. So fair use, they would submit, would apply in that situation. So they're using somebody else's copyrighted material, but they're creating something new. So Fox is making the same claim for posting these two photos, which it did not have permission to use, on Facebook, that was inviting comment and it was transforming the nature of the content. The owner of the image, North Jersey Images, says that's baloney. You were using our image to create more of an audience for your product, and it therefore harms our ability to make money with our product. Many critics are saying this is very interesting that a news organization that depends on copyright is trying to assert that copyright doesn't apply in this situation. So the interesting thing will be if Fox wins this argument, will the same argument be used against them when they have exclusive video of something and another news outlet posts it on its Facebook page? Will Fox try to sue them? BuzzFeed has also been sued a number of times over some of its listicle content. So they're using material that someone else has created, photos that somebody else has created, and they're pulling them into their listicles without permission, saying that it's transformative content. Sometimes they win, sometimes they lose, but copyright is being challenged, as I said, fairly regularly in the new media and in the social media space. Free speech and students. I do think that this was an interesting element of the textbook that was worth our discussing. In the case called Hazelwood versus Kohlmeyer, essentially the court said that high school newspapers are part of a classroom exercise and they're not really protected by free speech in the way that a traditional newspaper, a professional newspaper would be. According to the courts, administrators can censor publications for content that they think is going to create legitimate pedagogical concerns. So essentially they're saying if the administrators believe this could interfere with teaching and the educational climate, then they can restrict the speech. This is an important reason why Ole Miss and many other universities have independent student media, which essentially says that what's reported in the DM or on Newswatch, Rebel Radio, in the yearbook, that those decisions are ultimately made by the students in charge of the publications. Though they seek advice from journalism professors and the student media directors and others, at the end of the day, those decisions are made by the students, and that allows them to be protected by free speech. So media law challenges are going to continue. There are lots of areas of media law that are yet to be resolved. I've already talked about who is a journalist. This seems to be a real sticking point in the passage of a federal shield law. Who owns social media content? We're going to see this play out time and time again. If I post something to social media and somebody else uses it without my permission, what's my legal standing in terms of allowing them to use that content? Who has jurisdiction when content is posted online? There's a case playing out involving Facebook, a photo of a nude woman in a painting. So it's a photo of a painting that is believed to be in violation of obscenity laws in France, is now caught up in a court battle in which French law is trying to be applied to a U.S. company, which is Facebook, and all of those issues surrounding that, with the global nature of the internet. What laws apply? Is it where the company originated, where the content originated, or some combination? Again, many, many things to decide. And then the data collection and invasion of privacy issue is bound to be caught up in media coverage. How much information is collected about us, and what will happen if that information is used by a media organization? Who's responsible for the invasion of privacy? Is the organization that collected it? Is the media responsible for publishing it? As always, don't forget that I'm looking for tweets, which could end up being extra credit for you on your final exam. Use the hashtag UMJOUR101.